Now, if the entirety of clause 16 were not to apply to Jammu and Kashmir,
Yes.
what was the reason for saying that only clause 16(3) will apply subject to these modifications?
For the simple reason that Miller's other clauses in respect of clause 3 of the Constitution came into the J&K Constitution later. And I'll show that to your Lordship.
But is it your contention, therefore, that
entirety of 16 applies?
16(1) didn't apply to the Jammu and Kashmir?
It did apply. It applied.
The part which is mentioned.
But how did it apply then?
No, part 3 applies in full. When it says part, your Lordship may see they have a serial number and then they have A, B, C below each of these parts. So when they mention the part applies in full. Now, in that part, A, B, C will tell you the exception or modification of the provisions of the Constitution in that part. So when the part is indicated, the part applies in full. In the 1950 order, it was column. So in the second
That's what I was saying. See, in the earlier, the manner of printing of the two notifications
Yes,
is slightly
that's
different.
all. That's all.
very good.
In the first one,
has been
there is a
expressly
column,
excluded.
it is an article.
Yes.
Then what is the exception sort of
Correct,
carved
correct.
out?
And the modification. Now it's
Modification exception carved out.
So now
In
it's
this, the way it is printed as I see it,
yes.
when they say part 3, it means part 3 applies, but
these exceptions and modifications.
column of modifications which were there
Yes.
are specified underneath it.
That's
Exactly.
exactly what it is. Nothing, no difference.
Other than what has been explicitly excluded,
Yes.
the rest of the part 3 applies.
That's correct. That's all that there is. That's all.
This is Sibal.
Like
I
16,
think
1 and 2 apply.
this is Sibal. Just cut to page number, internal page number, the first page, page 10 of the
Page
notification.
10, okay.
The provisions of the Constitution.
Yes.
This means the entire provisions of the Constitution.
Page 10, your Lordship's PDF page 10?
Yes,
Yes.
that's a notification, 14th May 1954, 2, clause 2. The
Page
provisions,
13, not 10.
13 of the
or page 13,
Yes,
yes,
13.
yes, page
Yeah.
13, you're right. The provisions of the Constitution,
Yes. Yes.
which in addition to Article 1 and 317, Article 317,
Yes.
because that's covered by 3.
Yes, yes.
Now, the provisions of the Constitution refers to the entire provisions of the Constitution.
Correct, correct. Yes.
Shall apply in relation to the state of Jammu and Kashmir. Full stop.
Yes. Which,
Second-
the word
second-
also left the word out, which.
Yes, I'm aware of that. That second part says, the exceptions and modifications subject to which they shall also apply shall be as follows.
Correct, correct.
So thereafter, the exceptions are carved out
Yes.
with regard to each part of the provision of the Constitution, which are either not to be applicable or applicable with modification.
Correct, correct.
And if you go down, it specifically says 356 is excluded.
Yes.
In case this was specific inclusion, they need not have specified 356 is excluded. Because by implication, 356, if not mentioned in the schedule, would have been excluded.
Brothers, with the greatest respect, when you say kindly read it, just see. Kindly see part 18.
The very fact that some articles have been
Kindly see
excluded,
page 18. Kindly see page 18. PDF page 18.
yes,
Which is this.
See part 18.
See part 18.
Part 18.
352, the following new clause shall be added. Above that,
correct,
part 18.
correct.
And therefore there are exceptions.
We are then at item.
But the part applies, but there are exceptions and modifications.
So like part 18 applies, for example, part 18 applies,
Yes.
the modification is specified below that.
Yeah.
Then small clause B, 13, part 3, small b.
Therefore, there is no dispute on
The
that.
entire Constitution has been
356,
applied.
357.
They will accept what
Exactly.
So these three articles of part,
Which shall apply shall be as follows.
Will not agree. That's correct.
Kindly see, and also it says the provisions which shall apply shall be as follows. Which shall apply? They are enumerating the provisions, that's all, Madam.
the next after that is what are the modifications?
Yes,
Or what is omitted. So
that's right.
mostly they are modifications, but some are omissions.
Yeah.
For example, in part 19, if you see,
Yes, I have it.
Article 362 and 365 are omitted.
Omitted, yes.
366 clause 21 will be omitted.
Omitted, correct.
Otherwise, the whole of part
Will apply.
19, other than this will apply.
That's right.
The approach is instead of going provision by provision and enumerating 395, they went part by part. And they said this whole part applies subject to.
But
But
ultimately,
what about those parts which are not specified as parts?
They don't
they
apply.
don't apply.
No, that is a problem.
that's-
I'm not sure you're right on that.
You may not be right on that.
We have, in fact, in volume 1, we have the Constitution of India as applicable to Jammu and Kashmir, which shows that this is how it was.
Part 4 won't apply.
No, not at this stage. Not at this stage. Part 3 did not apply till 1954. Preamble did not apply till 1954. That's exactly the way they proceeded.
Well, that's the only.
And this is significant.
I think 15.
PDF 15. No? The part your lordships are referring to is?
If everything applies.
Yes.
Why were they specifically?
Yes. So part 4A is omitted at that stage. 4A came later anyway, but part 4.
The one way to look at it is part 4 will absolutely apply, of course, but without any modification.
Well,
But
that, with
where
respect,
there is
that's not the
modification, then
understanding,
it's specified.
that's not the understanding of the government of India then. That's not the understanding of the state of Jammu and Kashmir then. That's not the understanding, Malad, of any authority. Then, Malad, now we are saying, no, that was all wrong. Actually, everything
We're
applies.
not saying, we're just
And they don't,
discussing.
and you don't need consent.
Mr. Sibal, as I see it,
Yes.
every order
Yes,
extended different parts of the constitution
that's right.
to Jammu and Kashmir. Now, if a particular provision is a modification, it says so. Now, it may be by provision wise,
Yes.
or it may be part wise,
Yes,
it may be by any method,
correct.
but it keeps on extending by the
Yes,
orders
yes.
which are passed.
Yes.
So first one was provision wise in a sense. This one is part wise because practically the whole part was to apply
Yes,
with certain modifications.
that's correct.
To the extent that it is not to be applied, it is excluded.
That's right. That's the only submission. That's the only, and in any case, Malad, 1 and 3 are, 1 and the 370 are excluded.
That is from because of the first notification, separate clause C was made.
That's correct.
Clause C was made for Article 1.
So, Malad, this argument then doesn't take us anywhere because we are dealing with 370. We are not dealing with any other part of the constitution. So we can, Malad, interpret the orders any which way you want, but it cannot touch 1 and 370.
The two major points to my mind are this. One is your submission that Article 370 has acquired a permanent feature of the Constitution.
Yeah.
That's the debatable issue.
That's it.
Which both sides will debate. Next is suppose it is not permanent. Then what is the manner of abrogating Article 370?
That's right.
Is that procedure followed or not?
That's correct.
The only two issues as I
Correct,
see it
correct,
in the
correct.
whole
But I'll
issue.
hope and try and convince you that it is permanent. I will try and convince you. I know, Malad, your lordship says it's debatable and it is debatable. There's no doubt about
So
it.
both things are debatable means both sides will argue this
Yes,
point out.
it's really debatable. But I tell your lordship, Malad, why it is permanent. Malad, now, for the moment, Malad, because we have only dealt with the Constitution of India.
Debate will also be on the second point. I look at a debate whether
Of course.
the procedure has been followed or not followed. They will say we followed the manner of abrogation.
Absolutely.
You will say not.
Now, Malad, so far I've only referred to provisions of this Constitution. But, Malad, your lordships will have to look at the Constitution of Jammu and Kashmir. Because that Constitution, Malad, was framed and cleared in 1957. So, Malad, Malad, Parliament could only exercise, if it takes over under 356, declares an emergency, it can only exercise the powers of the legislature. That's what Bomai has said, and I take your lordship, you can't do anything more than that. Right? Now let's look at the provisions of the J&K Constitution, which will give you an idea as to why it's permanent. Yeah. Malad, I'm sorry, my understanding is right. Before we go to that, Malad, kindly see the volume 1. Now, Malad, kindly see, this is the Constitution of India as applicable to Jammu and Kashmir, just before abrogation of 370. Your lordship has that?
Part 4 doesn't figure in it at all.
Yes. And there is no order omitting it.
This is which year?
This is just before 370 was abrogated.
It's taken from a book of 2016, but it's as it stood there.
Part 11 is page 49. So nothing is excluded. There's no specific provision. Therefore, the order says provisions which shall apply shall be as follows. That's why, Malad, the 54 order says what it says. provisions of the Constitution which shall apply.
So notwithstanding the deletion of the word only,
Yeah.
the word which seems to indicate that these are the
That-
parts, the provisions which will apply.
So that's Mullah's really. Now Mullah's in this context, kindly look at the Constitution of Jammu and Kashmir as it was cleared in 1957, passed in 1957. And remember Mullah's,
Publication or government publication?
it's not a government publication, Mullah's, but
Accept this position.
this is not hopefully not in dispute, Mullah.
But Mr. Sibal, you are right that the constitutional practice which was followed since the adaptation orders proceeds on the basis that government selectively applied provisions of the Constitution to Jammu and Kashmir. They never treated it as if all provisions apply. Though really clause D is susceptible of two interpretations, but the constitutional practice supports what you are arguing. We'll of course have to hear the learned AG on that.
Now, Mullah's, we move on to what happened in 1957 when the Constituent Assembly, Mullah's, drafted this constitution and was adopted. And Mullah's, remember the 1954 order came when the Constituent Assembly was there. They had a choice. They could have said, no, we want.
57, what happens at 57? Let's see then. for
Yeah, but I'm
57.
just saying the Constituent Assembly was constituted in 1951, I think on the 10th of May, if I remember correctly. And then Mullah's 54 order was passed. They could have said, look, no, we'll abrogate 370 and be part of India without conditions and be like any other state. They chose not to. And you will see that, Mullah's, in the Constitution itself. I'll show, Mullah's, it's better we look at the
There is
Constitution.
no dispute about the proposition. 370 remained in the Constitution.
Yeah.
So nobody is arguing that 370 was not there. Otherwise, where was the occasion to abrogate it? Only issue is whether it requires a permanent character,
Permanent character.
which cannot be touched, or whether there is a methodology, right or wrong, there is a methodology by which 370 can be abrogated.
Correct.
That's the first part of your argument, as I understand.
Correct.
And in the alternative argument is, even if you don't accept my first part of the argument,
The methodology was wrong.
methodology was wrong.
No, sir, I'm sorry to interrupt, but on this permanent statement, 370 is in three parts. The first part, our argument is, continues, always. Second part is transitory because it's dealing with what happens before the Constituent Assembly comes in and Constituent Assembly has to ratify. The third part is temporary while the Constituent Assembly is there. Just putting it in a nutshell, that's our argument.
Yes, you are saying, according to you, 370 is structured in a manner
Yes,
whereby some part will go away or become
Yes.
otiose, and some part becomes otiose because in 1957, some
Correct.
other part becomes otiose
Correct.
later on. So you say one has a permanent feature. That is our
the
argument. we
Constituent
want to-
Assembly effectively had a choice to exercise three or to allow one to
Till
continue forever.
1957. Your argument is all these choices were available only till
Yes,
1957.
that's our.
That is your argument.